Hey everyone, welcoming you all. So in today's video, we're going to understand Article 20 of Indian Constitution. So let us get started. So here, as you can see, it is a safeguard for accused person under Article 20 of the Indian Constitution. So Article 20 of Indian Constitution explicitly talks about accused person and their safeguards, and it's a very important topic for criminal law students also. So now we will learn about it in detail. So you can see safeguards for accused person under Article 20 of the Indian Constitution. So introduction says Article 20 of the Constitution guarantees certain safeguards to a person accused of an offence. So basically Article 20 guarantees some of the safeguards to people. Who are the people? They are people who are accused of an offence. It says no person shall be convicted of any offence except for violation of a law in force at the time of the commission of the act charged as an offence, but not be subjected to a penalty greater than that which might have been inflicted under the law in force at the time of the commission of the offence. So, clause 1 talks about that no person shall be convicted of any offence except for violation of a law. That means if a person haven't violated any act or any rules, that person will not be considered as an accused person. No person shall be prosecuted and punished for the same offence than one. It also says that clause 2 that if a person has already got his punishment, so for the second time they will not be getting any kind of punishment for the same offense. For example, if a person stole something and he got punished for that in the year of 2011, and in the year of 2012 the same topic has been brought out and he was punished for the several times. So this thing cannot be happen. If he has already got his punishment, he will not be convicted for the same offense twice. No person accused of any offense shall be compelled to be a witness against himself. So this talks about any person who has committed the crime himself cannot be the witness of his own crime. So this is the all the three clause of Article 20 that deals with safeguards for accused persons. Now let us know about Article 2 in an overview. Article 20 provides three safeguards to person accused of an offense. So basically under Article 20 we got particularly three provisions which talks about safeguarding person who has been accused of an offense. Protection against ex post facto law. So this is the first in Article 20 clause 1. Protection against double jeopardy. This is in clause 2 of Article 20. Protection against self-incrimination. It is in 20 clause 3. So this uh, all the 3 points have been discussed just now. So again, we'll be discussing all these three provisions in detail. So let us know about what ex post facto laws under Article 20 clause 1. Article 21 provides against ex post facto laws similar to the US Constitution. So US Constitution also have similar kind of rule in their country itself. Ex post facto laws impose penalties retrospectively or increase penalties after they act. First part, no person shall be convicted for an act that was not an offence when committed. A person can be punished only if the act was an offence at the time of its commission. Civil liabilities like taxes can be imposed retrospectively. Example, a tax law can apply from a past date, so except that others cannot be, added in a retrospective manner. Law cannot later make an innocent act criminal. For example, if someone stole something and at that time committing that there was no such rule or act which had the punishment prescribed for a person who stole something, and later after 5 or 10 years there is an act talks about that if a person commits something then he will punish it under the law. So it cannot happen in this case. Second part, no higher penalty than the one in force at the time of the offence. So say, same example we'll take. For example, in 2012 for stealing, you have to give 5,000 rupees as in penalty. In 2020, you cannot increase it up to 50,000. So it has to be the same which was before. Ban covers both passing such law and punishment under them. So now relating to this, we have a very important case law. This is Bahadur Singh versus State of UP, and All India report was 1958, Supreme Court 1994. Penalty refers to the punishment for the offense committed. So in this case, the very meaning of penalty has been given by the Supreme Court. Now let us know about what is double jeopardy under Article 20 Clause 2. As I said, double jeopardy is again is something that you cannot be punished for the same offence twice. No person shall be prosecuted and punished for the same offence more than once. Based on maxim nemo debit bis vexed. So when we talks about law, maxims plays a very important role. So many of the maxims were have been derived maybe from French, from Latin, and they have a particular meaning. So when we talk about Article 20, it has also a maxim, and this says no one ought to be vexed twice, or no one should be tried uh, tried twice for the same offense. So same meaning as I said, but it based on this particular doctrine. Only applies if there was a prosecution, there was punishment, it was for the same offense. As I said, there has to be some condition met in order to use that double jeopardy for one's benefit. Now let us talk about limits of double jeopardy. So it has some limitation in it. Double jeopardy means a person should not be tried or punished twice for the same offense. As I said, in English law, a person can take the plea of atrefos acquit, that means already acquitted, atrefos convict, already convicted. So it is in the other countries, for example, in English law in the USA. In the USA, the Fifth Amendment prevents a person from being tried twice for the same offense, protection from double jeopardy. So it was came under Fifth Amendment in the USA. Now we will talk about Indian law. Under Article 20, Clause 2, only recognizes authorized convict, not authorizes acquit as a fundamental right. But in India, we do not apply both this. We apply only one, and that is authorized. Authorized convict. So we will only apply this thing only in India. So retrial of the acquittal is not constitutionally bad in India. So there are some differences between US and Indian constitution on the matter of double jeopardy. However, a legislature may give statutory recognition to atrefous acquit. Article 23 applies only if there was both prosecution and punishment in the first incident. As I said, in order to meet double jeopardy, there has to be some requirement that has to meet the very incident itself. Section 26 of the General Clauses Act 1987 already reflects this principle to some extent in Indian statutory law. So here also Section 26 of the General Clauses Act in the year of 1897 plays a very important role. Now let us know about some of the important cases relating to this particular double jeopardy. Key cases: Maqbul Hussain versus State of Bombay in the year of 1953. A man was caught with gold at customs and penalized. Later criminal proceedings were started. Held, customs proceedings were not prosecution, so Article 22 did not apply. So as I said, it has certain limitations. So in this case, what happened? A person got caught at customs and was penalized. Later, it was held that just because it was not prosecution, it was penalty. So this article will not be applicable in that case. Next, we have Leo Roy versus Superintendent District Jail in year 1958. Man punished for violating tax law and later charged under penal law. Held two separate laws, not the same offense. Article 22 not valid. As I say, tax laws has an exemption in this part of double jeopardy. So in this case, what happened? It was held that both that were two separate laws and therefore not the same offense. So Article 22 is not validated. Now let us come to the third case in the row, is Kalavati of the state of MP in the year of 1953. Clarified that Article 22 applies only after actual punishment, not just prosecution. So in this case, various meaning has been given. What are the meaning of prosecution? What are the meaning of punishment? So in this case, the court come up with this particular, you know, judgment. Now let us know about the third safeguards in this manner, in that is Article 20 Clause 3, which talks about self-incrimination. No person accused of an offence shall be compelled to be a witness against himself. As I said, if a person has murdered someone and he says that I will consider myself as a witness, in that case, that will not happen. You need to bring other witnesses in order to make a person guilty. Applies only to accused person. So this is only applicable to the person who is already accused of such crime or such relatable crime. Does not bar voluntarily testimony. So these are the requirement, or these are some of the meanings that falls against the safeguard protection against self-incrimination. So that is all about Article 20 of Indian Constitution, which talks about certain safeguards relating to person who are accused of. So if you find this video helpful, do like, share, and subscribe. So we'll be meeting you in another such content. Till then, stay happy, stay healthy. Thank you for watching the video.